Welcome all. We're going to jump in here today to our Gilfix weekly webinar, The Astounding Power of Multi-Generational Planning. We're going to go through 7 ideas for your family, 7 examples of what this is, how it works, and the incredible impact that it can have. It's really powerful stuff. And we are a multi-generational team. You can probably see that. I'm Mark Gilfix, and this is Michael Gilfix presenting with me here today. Father-son team. Our firm is not just us, but we specialize in helping families in a multi-generational way. It's not a fit for every family, but for those where it is a fit, it is truly astounding what we can achieve when parents, grandparents, children, grandchildren all work together and when we plan across generations. And we're going to give some examples of that. What are we going to cover here today? There's a lot. I promise you we're going to get through this efficiently. As part of that, we can't really take questions during the talk, but please, if you do have questions, enter them in the Q&A function. We'll try to get to those at the end. But we're going to talk first about the secret trust that ultra high net worth families have used for generations to protect assets. We're going to talk about what those are because they are integral to a lot of the subjects we're going to cover for the rest of our talk. We're going to talk about 7 specific examples and ideas that you can deploy for your family around multi-generational planning. 1, we're going to talk about how adult children can reduce estate tax exposure and protect their assets by actually gifting to their parents. Something that might be a little unusual in your mind. Very powerful. 2, how grandparents can support their grandkids and avoid estate and gift tax exposure while doing it. Win-win all around. We're going to talk about how parents can help children to purchase a home, protecting that investment from divorce, lawsuits, and even future taxes. We're going to talk about what parents have to do to save the family home or other properties, kids and future generations without massive property tax increases. It does require working across generations. We're going to talk about how parents can reduce or eliminate estate tax exposure, those who have larger estates, while helping the family all along the way. We're going to talk about long-term care, an example of how assets can be shifted from parents to children to protect the parents and to supplement long-term care needs while getting help from government benefit programs. And we're going to talk about charitable giving and how parents can include charitable giving in the family plan to include future generations and even support future generations in a way that really shares multi-generational values. A lot to cover, yes, but I promise we'll get through it very efficiently. And I think it's going to be so powerful for you and your family. Think of which ideas apply to you. And we can help you with this. And I have to point out, this webinar is for educational purposes only. It's not legal advice. This doesn't form an attorney-client relationship. We have to meet with you to give you real legal advice. So on that note, Mike, what is this really about?
Well, let's. By the way, this is me and my wife Myra and our grandson Miles, who's just had a 2nd birthday. He's a wonderful guy, great relationship. So yeah, we do think about him and others as we delve into this topic. It's personal to most of us. I mean, probably everybody on this call, on this webinar, it's very personal to you because it is about our families. You know, it's kind of trite to say it's about our families, but what we do is we sort of weaponize that. We make it happen in ways that are creative. And Mark reiterated or identified the topics we're going to go into today. It's just a fresh way of looking at things. Last is kind of an historic note that traditional estate planning is really different than this multi-generational approach. You had your client in front of you and you only talked with your client, period. And others were not involved. And we do presumptively take a different approach. We involve the family members. So it's different. We're not the only ones in the country to do that, but we certainly emphasize it, we live it, and we breathe it.
Yeah, and just for those of you who don't know our firm, obviously Gilfix and the Pohl Associates, we're really proud of our heritage. We are national leaders in our field. We publish regularly in legal journals. We speak at legal conferences. We've trained other attorneys about multi-generational planning. 40 years as of next year in the Bay Area. We serve clients throughout the state of California, from down in San Diego all the way up to Wairika, and we are a multi-generational team. That's actually a photo of me as a child with my mom and my grandparents. We've served thousands of families in the community, both locally in the Bay Area and again throughout the state. Our goal is to work with you and your entire family, if we can, to provide extraordinary value, return on investment, and peace of mind. And that's what this is all about. How can we help you and your family to achieve your goals? Very proud that we've also been featured in the national media about this, but we think about this all the time. We live it, we breathe it. This is what we do. So Mike, why don't you talk a little bit about what we really mean in more specific terms about multi-generational planning?
Okay, so you get the flavor. I mean, in a way, conceptually, it's extremely simple. And frankly, I think it's obvious that it's a matter of coordinating plans between the kids, the parents, and the grandkids. Rather than just thinking in a very simple manner where you're only focusing on one generation, we're thinking about all three. I mean, there you are. And then question, of course, is what do we do about it? We'll go through that. How do we implement it? Simple, yet it's not typically done. Okay. Mark alluded to the fact that we've published a number of articles about multi-generational planning. We've given talks at national conferences on this, educating other attorneys, trying to get others to take the same perspective and the same semi-aggressive view as we look at planning. It does require a good relationship in the sense that if you're going to be integrating your kids or grandkids into your thinking and your planning, how and to what extent are they going to have power? Are they going to share assets with you? It's not simple. So we emphasize there is no one plan. There is no one size fits all. Each family is unique, needless to say. So each plan is unique. It reflects and reinforces the values of a particular family. Last point, as we just go through this definition, is that we have traditionally focused 90% on the legal and tax planning side of things. We've done a lot of work in the field of life insurance. Mark in particular is now putting together a more comprehensive team that is integrating legal and financial planning. Again, in a way, it's obvious that should be done, that your team should include somebody who understands financial matters, investments. How do you coordinate that with a need for long-term care, with tax, all of these things. So again, that kind of planning should mesh nicely with the legal planning that you're doing. And in fact, the insurance and financial advising professional we're working with is starting to come to our office once a week. He's in here tomorrow, available to chat with folks. But Mark will talk about that a little bit more later. We're very excited about it, and we think it's very appropriate, very client-centered.
Now, what your estate plan has to be up to date for all of this, by the way. And we are very excited about that program. And part of this, you need to make sure that your documents are up to date. So Mike, what do we mean by making sure that your estate plan is up to date?
Sure. And again, up to date doesn't just mean you did it at some point. This third or fourth bullet here is the need to review it. Things change, the laws change, the nature and size of your estate changes, family relationships change, etc. So the 4 key documents, everybody should have these, we strongly believe. A revocable trust, that's your living trust that I'm sure if you're our client, you have it. And you have it appropriately drafted to fit your circumstances. If you don't have it, you need to do it. Obviously, we're available for that. A durable power of attorney that needs to be sophisticated. We'll go through the reasons why. The last power of attorney that we drafted that I looked at for a client yesterday was 17 pages long, not a 2-page check the box kind of form, which doesn't work in all circumstances. Everybody needs to have an advanced healthcare directive, 18 years of age and over. Everybody should sign one. And the family protection trust, one for each child, implementing the concept of multi-generational protective planning. So, you can find discounted anything. We obviously believe that that's a mistake because, again, you are not vanilla. Vanilla works only when there's absolutely vanilla circumstances. So, you just shouldn't do that. I'm sure you understand that. There is a need to review it. If you have a trust that's been around for many, many years, it may be out of date in so many ways. We meet with countless families who did their trust somewhere else, and they want us to review it. Most of the time, we redo it, sometimes not. So it's a matter of looking at what you have in place, making sure that it suits you, fixing it, upgrading it if necessary. We're eager to do that for everybody.
So now I
want to supercharge, Mark.
Yes, I want to talk. We're going to talk about a mystery as we uncover, because it's going to be core to a lot of what we speak about here today. Let's just compare Larry and Wyatt. Larry and Wyatt, both of them have parents who leave $2 million for their benefit. Both of them, imagine them living the same lives. Both of them inherit the $2 million. Both of them endure divorces. Both of them endure lawsuits. When Larry passes away, the $2 million that was left for him is gone. None of it goes to his kids. None of it goes to his grandkids. Wyatt, same thing, divorce, lawsuit. Because of a difference in planning, when Wyatt passes away, that $2 million has grown to $6 million, and it goes to his kids. And when his kids pass away and it goes to his grandchildren, that's grown to 18 million. And these are not outlandish numbers, a difference of $0 to $18 million. Yes, that can be the difference, starting out with not that much. I know $2 million is a big number, but in most parts of California, that's the price of a house these days. Massive difference across generations. Now, what's the difference? Family protection trust. Let's talk about these. Why does Bernie Sanders want to get rid of these? That's not a political statement. He's on the record saying that he doesn't think these trusts are fair. And that's for you to decide. But ultra high net worth families have been using these types of trusts for a long time, and we think that your family should be able to use them too. There's a lot in the media about these types of trusts. Why? So here we're talking about, let's say you have 2 kids, you have your living trust, and instead of leaving half my estate to my, let's say son and daughter, half estate to my son, half to my daughter, you would actually leave it half to a family protection trust for your son and half to a family protection trust for your daughter. Why would you leave money to trust and not to your kids directly? 3 big reasons. 1, if either of your kids endures a divorce, or if your child endures a divorce, inherited assets can be commingled and lost in a divorce settlement. They're in one of these trusts, they remain separate. They should not be touched in a divorce settlement. 2, if your child is sued, inherited assets are absolutely exposed in a lawsuit. Assets in a family protection trust have a barrier, a high level of protection against potential litigants. 3, this is huge. It's hard to wrap your head around this. But when you leave money to your child directly, that money is part of their estate, of course, and anything that they earn is also part of their estate. So it's all added up, and when they pass away, all of that is exposed to estate taxes. We don't know what estate tax laws are going to be like in 10 years, in 20 years, and 30 years, but it's very possible they could be very strict. If you leave it to a family protection trust instead, subject to some limits, that money should go tax-free from your children to your grandchildren. And that's where it can save millions of dollars, even if you're not starting out with that much. And you might think, well, this is great, but I don't want to tie my kids' hands. It sounds too complicated. You can name your kids to be their own trustees and to manage their own trusts down the road, so you don't have to tie their hands. So it's an incredibly powerful trust. They last for about 100 years in California. So it's kind of like a prenuptial agreement for your kids, your grandkids, and even your great-grandkids. And it is not just for the ultra wealthy. If you have any assets, if you have a home in California, you should create family protection trusts or a trust for your kids. It is a critical part of multi-generational planning. We're bringing this up now because many of the examples we're going to give use family protection trusts as part of the process while you're still living. This isn't just about what happens after you're gone. What can you do with these trusts while you're alive? So a lot of the examples will talk about that. So let's circle back just to close the loop on this. Larry and Wyatt. Remember, Larry left with nothing. Wyatt ends up with 6 million when he passes away. His grandkids end up with 18 million. Very simple. Larry's father left the money to him directly. So when he got divorced, half of it's gone. He gets sued. The rest of it's gone. Wyatt, the money was safe in a divorce. The money was safe from the lawsuit. So his money grew and it was able to compound over years. 2 million grew to over 20, 30 years grew to 6 million, which over another 20, 30 years grew to 18 million. Massive difference. So that's why we feel so strongly why every family should have a family protection trust where appropriate. So let's talk about
the ideas.
Idea number 1, and let's just get all the text up here.
And actually, before that, I want to harken back to what Mark referenced about Bernie Sanders. The reason he doesn't like Dynasty Trust, it's part of his platform, he's on record, is because it helps families retain wealth in the family. It avoids exposure to estate tax, which over time is millions and millions of dollars. So if you're an advocate for increased tax revenues, for redistribution of wealth, obviously you'd be a critic of Dynasty Trust. Most families, however, want to keep the wealth in the family. So, Bernie's consistent, to give him great credit. His views have stimulated great interest in Dynasty Trusts.
Yes.
Okay, multi-generational idea number 1. Now, this is really interesting. It's an example of creative thinking, frankly. Okay, so now we're looking at a family where the daughter, Sarah, is very successful financially. She's got a couple of kids. Her estate is growing to the point where she's probably going to be exposed to the 40% estate tax when she passes away, she and her husband, okay? So she's concerned about this exposure. While the current level of estate tax protection per person is very high, in 2026, it's not going to be low, but it goes down to a little over $6 million per person. Still a lot. That's like 13 million for a couple. And it could be reduced even further depending on so many factors. She may be concerned about the money that she's accumulating also because that money is exposed to litigation. So what can she do? Now, obviously, there's steps she can take to protect assets for her children, which we'll get into in a few minutes. But here's the creative thought. Okay, let's look at what Sarah might do.
Yes, you can go ahead. The slide is a little bit
Oh, it is.
stuck
Okay.
at the end, the
Okay.
share.
So the next slide, well, the next visual will make the point that Sarah and her husband can make gifts to Sarah's parents. Oh, why in the world would she do that? I mean, give it away to her parents? Okay. The assumption here, number one, is that her parents do not have a big taxable estate. So what Sarah and her husband are going to do is first they might give her as much as, let's say, a minimum of $16,000 each. That's the annual exclusion. That's the amount of money that anybody can give away to anybody else, and they don't have to report it to the IRS. It's invisible. If Sarah wants to, she could give away additional assets, even millions, to her parents, and still avoid paying any tax on that, if it makes economic good sense. So what she's doing here conceptually is she's bulking up her parents' estate and reducing the size of her and her husband's estate. Okay, step two, Sarah's parents have their own estate plan. They're not going to leave money directly to Sarah, right? Because that money would come right back into her estate. What they're going to do is they're going to create a family protection trust for Sarah. They're going to modify their irrevocable trust to say that when we pass away, the assets that would otherwise go to Sarah are not going to go to Sarah. They're going to go into the family protection trust. So what do we do when we achieve that? Number one, if Sarah had stock, for example, she gives it to her parents when they pass away. If it's in their estate, she gets a stepped up basis, which means if she wants to sell that stock at that point, no capital gains tax. Number two, the money is going into her family protection trust. So what may be a few $100,000, it could be a couple of $1 million. None of that money is part of her taxable estate. So she shifted money upward. They pass it along back to a trust for her. It avoids inclusion for her estate. And that could save millions of dollars for the grandkids, for Sarah's children. Also remember that the assets that go into the family protection trust are protected from litigation in the event that Sarah is sued. So again, we're capturing so many levels of protection by being creative, utilizing these asset transfer rules, being very sensitive to many, many tax issues, removing assets from the taxable estate for this family, saving a small fortune for Sarah and for her kids, for the grandkids of Sarah's mom and dad. So, I want to add, by the way, folks watching this, you may be the grandparents, you may be the parents. So, you're thinking not just about you, you're thinking about integrating the planning. So we think this makes an enormous amount of sense for folks with larger estates. And in Silicon Valley, we have so many kids being in their 30s, 40s, 50s, who have large estates. So we always revisit this issue. Okay.
Let's talk about grandkids.
Multi-generational planning, number two. This is how grandparents can support grandkids in particular. Okay. Many of us are grandparents, or maybe we're the parents of kids, and mom and dad are the grandparents. And we want to do something for the grandkids. They're young enough, they're perfect. They're still perfect. they're so young. Okay, so there's many things we can do. Grandparents can pay medical expenses, tuition, for anybody, by the way, and that doesn't count as a gift. It removes assets from the estate. So you might just focus on the grandkid and looking at bills that might be paid on behalf of the grandchild. Again, tuition for private school, if there is one, any medical expenses, you don't give the money to the parents to pay the bills, you have to pay the bills directly. Okay, a little more creatively as we think about how to how to protect assets and make sure that that everything is protected going forward. Okay, so here's the idea that we think is so cool that is worth consideration for every parent. Okay, so many folks fund these 529 plans for education. Perfectly fine, nothing wrong with that. Of course, that money is only to be used for the cost of education. Not a bad thing, we're not against it. But the crummy trust, yes, it's called a crummy trust. Named after a family. The family was involved in a court case many, many years ago, thus the name. We like to call it the grandparents' delight. I certainly like to call it the grandparents' delight. So the idea here is we set up an irrevocable trust and the grandparents gift $16,000 a year, the annual, the amount that can be given away without reporting it to anybody. We shift it creatively into this trust for the benefit of the grandchild. Now, unlike the 529 plan, this money can be used for anything the trust identifies. It can be for health, it can be for education, it can be for housing. So it's got much more liberal opportunity to use the money for the benefit of the grandchild. The other thing, again, is 529 plans, which again, we're not against them at all. That's for education. So if a kid doesn't use the money for the cost of education, there's things you do with it then, but it's maybe not ideal. So here, rather than have the funds effectively lose their viability when a child becomes maybe 24 after education, or whatever the age may be, you can specify the term of this trust. So you can say, my daughter is going to be the trustee of this crummy trust for the benefit of my grandchild for many, many years. I want her to manage the money, and he doesn't get control of the money if there's anything left until he's 30 or 35. So again, you can substitute good management to make sure that the money is used wisely. It isn't that you're giving the money to the grandchild at a young age. You're having it managed until he or she matures. We have to be optimistic that they're going to mature. And only at that point in time would they actually receive any money that's remaining in the trust. So clearly this is to be thought about. It gives you a lot of satisfaction. And by the way, you could put $2,000 a year into this trust, $10,000. If you just use the annual exclusion, it's up to $32,000 if you're husband and wife, up to $32,000 a year, and you can do it once and never again. So it isn't all or nothing. But seriously consider this. It removes money from your taxable estate. It's for the benefit of the grandkids.
So now let's talk about housing, a big issue for all of our clients. California is so expensive. I mean, houses in the Bay Area or coastal California, really anywhere, are just such a reach for most young families. And we've helped many clients, probably tens of hundreds of clients over time, to help their adult children purchase their first home or condo. And many, though, they'll help with the down payment. There's a lot of ways they've done that. But a lot are very concerned about divorce. I've had 3 or 4 conversations in the last week with parents who want to help their kids out, or the last 2 weeks, who are concerned, though. They like their kid's significant other, but they're not sure if it's going to last. You can use family protection trusts to help your child purchase their first home if you want to help out. And I think the key thing is people get a little confused here. You don't need to put all the cash into the trust and the trust has to buy the entire house. It can be partial. So let's say you want to help a child out with a 20% down payment. Well, you could just give them a 20% down payment, and that's a nice gift. It's a flexible gift. They could do that. They just take title as 20% is theirs, and then they finance the rest, maybe with their significant other. Better approach, though, is if you want to do this, you set up a family protection trust, and the family protection trust gets the 20% down payment as a gift from you, and the trust makes the down payment. The trust then owns 20% of your child's home, and the child can finance the rest with their partner, their significant other, their wife, their husband. 80% that's being financed, okay, that can be their community property, but that the portion you're helping with has long-term divorce and asset protection. The family protection trust could own 10% or 20% or 30% of the house, and your children or your child can finance the rest. And again, the share that you gift via the family protection trust owned by the trust is protected against divorce, lawsuits, and it's not part of your child's taxable estate. You can still sell the house later. You just keep track of where the funds go. It doesn't tie your kids' hands, but it can be an amazing way to help kids out in a way that protects assets for future generations. So another relatively simple approach using family protection trust. Now, related to homes, if you already have a house and or if you're lucky enough to have rental properties or income properties, you need to understand the potential demise of Prop 13. And when we say that, Prop 13 is still law, but the demise comes in when it goes from parent to child transfers. That's what Prop 19 is now law in California, meaning parent-child transfers of your home and other properties can result in a massive increase in property taxes. They used to be protected. Now, largely, they are not. So when you leave a house or another property to your kids, you want them to have that. Well, can they afford it if they have a 1,000% increase in property taxes? We've had many clients who've experienced, I'm not exaggerating, 1,000% increases in property taxes when properties have gone from parents to children. We have done a lot of webinars and talks about this. Check out the Gilfix Law YouTube channel for more details. That's not the purpose of this talk. Suffice it to say, it's a huge, huge deal. I'm just going to give a very high level summary of what this law means. Without planning, if you are passing a rental property, a business property, a vacation cabin to your kids, if it's not your primary residence, if you don't plan ahead, there will be a full reassessment of property taxes when you pass away, when it goes to your kids. Whatever the house is worth at that time, or that property is worth at that time, property taxes will be reset 1.1, 1.2% of that value, not what you were paying if you have 13 protections. Your home, a lot of people think that, oh, my home's still safe. It's just not true. If you leave your primary residence to your kids, they don't live in it. They want to keep it as a rental. Without planning, full reassessment of property taxes to the fair market value. Even if they live in it, only $1 million in fair market value is protected from a reassessment. So in some parts of the state, that might be okay. But in the Bay Area, in the coastal Los Angeles, San Diego, that's probably not going to be enough. Your kids could face a huge increase in property taxes, even if they live in the house, unless they plan ahead. Now, what do we mean by planning ahead, and why is this multi-generational planning? Well, our firm has developed the Gilfix and the Pole, call it the Dynasty LLC process. It's a custom solution. It really depends on your family situation. Without going into many details, because it gets very complicated very fast, we can develop a solution to keep your property taxes low. It is not a simple process. It involves multiple issues, your family dynamics, who's going to be in charge. Your kids have to be involved. We have to deal with property tax issues, but we also have to weigh capital gains tax issues and estate tax issues. So we have to make sure that the solution that we develop for you makes a lot of sense, but we can prevent property tax increases. We can still help you to achieve the crucial step up in cost basis when you pass away, if that makes sense. The difference in planning versus not planning here can literally be over $1 million for one property. I'll just give a simple example. I'm a nerd and I used to be a management consultant. I did a lot of work in Microsoft Excel. I created a simple spreadsheet. Let's say you have a home worth $3.3 million. I mean, yeah, that's a lot of money, but in some parts of California, again, that's run of the mill, which is incredible to me. And let's say your assessed value, you've had it for a long time, is $300,000 because you bought it decades ago. Prop 13 has kept the assessed value very low. You're paying about $3,300 a year in property taxes. When you pass away, if you don't do any planning, and if that house is kept as a rental, property taxes would go up to about $33,000 to $34,000 per year forever, going up from there at 2% a year. What's the difference if a family works with us to keep taxes low for a house like this versus a family that does not? Well, don't worry about the details. Over 10 years, it's $360,000 saved. Over 20 years, it's $800,000 saved. Over 30 years, the time your child would hopefully hold on to that house after you're gone, we're talking about $1.33 million in property taxes saved for a family that went through the steps to protect low property taxes versus one that doesn't. So it's a hugely challenging problem, but we do have solutions. So if you're concerned about property tax increases, if you have properties worth a lot more than their assessed value, talk to us. We can help you come up with solutions. So let's now transition back to multi-generational planning idea number 5, avoiding an estate and gift taxes while helping your family. So Mike, why don't you go through this?
Earlier, I mentioned where the level of estate tax protection is going to be in really just a few years. In 2026, $6 to $6.5 million per person. Again, not a small, that's not meager, but sometimes just owning a home around here, pushes us over that limit. And keep in mind the value of your assets, their values, notwithstanding what's going on in the stock market right now, probably going to increase. I mean, history teaches us that very consistently. So you may be worried about the estate tax. Everything you have over the limit is taxed at 40%. So it's a punishing tax. So we have to be aware of it. Countless folks in this community are. Again, maybe your estate isn't over the limit right now, but in a few years it will be. So what can you do? Well, first thing to say is you can. I mean, there are countless steps that can be taken to dramatically reduce or even eliminate exposure to estate tax. We've mentioned some of the more obvious, so we'll just go through that very quickly. The $16,000 annual exclusion. That's giving that money away to anybody. It can be, it isn't just your family members, by the way. You can give it to your kids, to your grandkids using that crummy trust. You can't keep it simple. You can use the crummy trust to give away $16,000 per year to a grandchild, but to nieces, nephews, friends, godchildren you want to support, you can do that. You can pay tuition, medical bills, as mentioned earlier, for anybody you want to support. And again, those checks have to be made directly to the provider of those services. I've authored a book, I think very appropriately named Beat Estate Tax Forever, updated it about a year and a half ago. It identifies countless of the more sophisticated tools and techniques that we use to dramatically reduce estate tax exposure. And by the way, the tools that we identify in, I believe it's in chapter 10, that delineate and give some examples of these approaches, they're tried and true. There are some out there pushing the edge of the envelope strategies that we tend not to utilize. So everything in the book works. Transferring assets and capturing discounts as you do that. Utilizing Dynasty, family protection trusts, countless solutions, LLCs, partnerships, using irrevocable life insurance trusts, on and on. So we have a separate webinar that we've given on our YouTube channel. You see estate planning for high net worth families on the Gilfix channel. Check it out. Many examples given there. And again, if you don't have it, I believe our clients tell us the book is very readable, very understandable. The first iteration of the book was literally twice as long. The hard work was shortening it and giving readable, understandable examples. So the main point, and it's beyond the scope of this webinar to get into all of these strategies, but I assure you that countless strategies exist to coordinate planning, save hundreds, thousands, tens of thousands, millions of dollars for the family, keeping the money in the family, ultimately to the benefit of the grandkids, the great-grandkids, carrying money on to keep your family safe going forward. Next, long-term care. Long-term care. We've worked with so many families on this topic over the years, and we have another book. Mark and I co-authored this one, Facing the Reality of Long-Term Care. It is fundamentally up to date. There have been some changes in the law that we're not going to get into today. But the point is, most of us are concerned about this. We know that the vast majority of us over the age of 65 will need some form of long-term care. That's national data. I'm not just making that up. Countless studies show this. So what do you do? How do you think about paying the cost of care? Sometimes, not always, you think about qualifying for government benefits like Medi-Cal, which is a government program that, for example, can pay for the cost of nursing home care. So it's not for everybody, but where you have this concern where the cost of $10,000, $12,000 a month is going to bankrupt you anyway, it's usually better to save your money before qualifying for Medi-Cal rather than exhausting all of your money before qualifying for Medi-Cal. So what this typically, not always, but what this typically involves is shifting assets, making asset transfers to the next generation. If it's done properly and carefully in California, the impact on eligibility for Medi-Cal is negligible. Now, California is an island. If you're in Ohio, Florida, any other state, what I just said is not true. But in California, we have unique planning opportunities. So the idea is, again, carefully, when you're comfortable with the idea, when you have good kids, et cetera, you can transfer assets even at the last minute to the next generation and achieve eligibility relatively soon. Now, when you do that, because again, we're multi-generational, it isn't just taking care of the kids. When that happens, just an illustration of how we think this through. money might be shifted to the kids. Okay, then you become eligible for Medi-Cal, paying nursing home bills, but you could have needs that could be extraordinary that are not covered by Medi-Cal. Somebody to visit you every day, a supplemental caregiver, on and on with what it might be. We always recommend that if that kind of transfer happens, if gifts are made to the next generation, the kids, the next generation, they create a special needs trust for mom and dad. Any amount of money can then be shifted into that trust, does not interfere with eligibility for Medi-Cal for mom and dad, but it locks up the money for mom and dad. So in case the kids go bankrupt, get a divorce, die, God forbid, die before mom and dad, all this money is segregated. It's safe for mom and dad as long as mom and dad live. So again, the point is, by shifting in one direction, we achieve eligibility for government programs for the oldest generation, but we're also building in a lifelong safety net for the older generation while protecting assets for the kids and the grandkids. So, you know, it's like win-win. It's win-win for the family. We have this reference here to needing a sophisticated power of attorney, which harkens back to what I said earlier about not getting a check the box power of attorney. If you have this issue, if this happens in your lifetime, you develop dementia, and it makes sense to do this kind of planning, but you're incapacitated. You can't transfer assets. You've lost the ability to understand these concepts and do anything. Question, can your kids, can anybody use the durable power of attorney to make those transfers, to protect that money and achieve eligibility? Not if you have the check the box power of attorney. There must be explicit language in a durable power of attorney authorizing transfers in identified circumstances, and then it can be used. Then the power of attorney can be relied upon to transfer assets, again, with the objective of preserving money and achieving eligibility for Medi-Cal, for example. So that's an illustration of a very specific, relatively sophisticated provision that needs to be in the durable power of attorney of every Californian, unless you are extremely wealthy and you just have no worries about the cost of care. So again, we urge you to get our book. The planning strategies are valid. Yes, Mark.
Oh, no, I was just going to say, that's where, if you're not sure, set a meeting with us. We can review your power of attorney document and let you know if it has that language. I'd say 80 to 90% of the power of attorney documents we see do not have the language we want to see. It also goes to tax planning. Like if we mentioned this here, but a lot of the strategies we talked about before, what if you become incapacitated? If the power of attorney has the right language, your family can still take a lot of these steps on your behalf. If it doesn't, your family's hands are tied. So I think that's a really important point, the sophisticated power of attorney. We can help with that.
So let's shift to number 7.
Yes, multi-gen idea number 7.
Oh, what a great intro. Thank you. Number 7. These are not in the order of priority. But now here we have a situation perhaps where you have a taxable estate or a large estate, and or there are charitable social objectives that you value and you want your family to reinforce and perpetuate those values. So how can you kind of integrate some tax planning and imbuing your values in your kids and trying to get them to carry it on? Again, kind of a win-win multi-generational plan. So one of the best ideas is setting up a family foundation. We have set up so many family foundations where mom and dad create the foundation, they put money into it, and key point, they involve their kids and they involve their grandkids, they involve family members, so it becomes a family affair. If the children end up running the foundation, they can receive even a salary for doing so. But really, the point is that you're coordinating asset protection, saving money for the family. When you shift money into a family foundation, it removes that money from your taxable estate. So you might have lost 40% of that money anyway. If it goes into the family foundation, none of it is lost. You're actually avoiding tax exposure. So we're real fans of this. It's right for so many families. Another idea, which is very different from the family foundation, but it's a way of supporting your charity of choice, is what's called the Charitable Remainder Trust. This is in my book on tax planning, by the way. This is where you have an appreciated asset. You don't want to sell it because of capital gains tax exposure. You put it into this trust, and that can generate income for you for life, or if you like, it can be income for your kids for life, while ultimately favoring the charity of your choice. So there's so many issues that we consider and that we address before we identify planning options. It's our job, by the way, not to say, do number 3 and number 4. It's our job is to give you options. And our 7 multi-generational planning ideas are intended to give you food for thought as you go forward. So Marco talked about how we take care of this.
Yeah. So how can you take action? So, okay, your head might be spinning. We went through so much so fast. I get it. We get it. We sometimes overdo it on these. We just have so much information we want to share. That's okay if you feel a little bit overwhelmed. There is no one size fits all approach to multi-generational planning. Your family situation is unique and specific to you. And this doesn't work for every family. We get that. If there's a conflict, if there are communication issues, if there are sometimes cultural issues, we know it can be hard. This isn't for everybody. But for the families where it does work, it is extraordinary what we can achieve. We work with so many families to find the right multi-generational approach. And our firm has worked with thousands of California families. So we absolutely can help you. And that's just part of how we do things, how we think about things. Whenever we can, we want to work with multiple generations if everybody's okay with that. And the wonderful thing about this, by the way, and here's my mom with Miles again, my nephew, you can use these subjects to have meaningful conversations with your children and grandchildren. You don't have to talk about dollars and cents because, again, this is about family. It's about preserving assets really just to support your family. It's not about obsessing over taxes. But when you talk to your family about this, it tends to be a really good thing. Communication and coordination the right way can bring families together. And at the same time, you can save millions of dollars and really talk about your values and what you want to pass along. So this isn't just about taxes. It's about family legacy. It's about supporting your kids, your grandkids, and even your great grandkids. I mean, it's hard to make it in this world. The Bay Area, California is so expensive. And there are so many win-win ways to support your family and really bring your family together. So to me, that's really what this is about. I love it when I get to do meetings across generations. In the last 2 weeks, I probably had 3 meetings where kids and parents were both in the room or on Zoom with me. And again, we do these meetings via Zoom. Makes it a lot easier to do these because you have kids on the East Coast or parents in the North Bay and kids in Southern California. We can bring everyone together pretty easily. So it's a wonderful thing. And a few planning steps now can just save so much. And Mike talked about this before. We are increasingly of the belief that an integrated financial and estate plan is just crucial. When one hand is talking to the others, your financial advisor talking to your estate planner, are they working together to figure out a plan? And we work commonly with financial advisors. We help make sure assets are properly titled, beneficiary designations are up to date. We are developing programs, integrated services, where we will be working hand in hand with financial advisors, and we're developing a really exciting new program. So if you're looking for a new financial advisor and you want sort of your own family office where everything's in one place, talk to us. We are developing this and we're starting a pilot program for a few clients now. So talk to us. We can help set you up. I think it's going to be really exciting for a lot of families. I want to point out, our team is not just Mike and I. We have an estate planning team of 5. We have Nick Klingenberg. He's fantastic. Renee Conrad, also fantastic, incredibly experienced. Francis LaPole is our tax guru. He's the former mayor of Los Altos, and I think one of, if not the best tax attorneys in the country. We have an incredible breadth of experience, and we all work together. So if you work with Nick, you're also working with all of us. There's an issue we're not sure about, we work together for every client. So should you set a meeting with us? Because of course, we'd love to get the opportunity to meet with you. Well, here are a few reasons why you might want to set a meeting. Do you have an estate plan? If you don't, definitely set a meeting with us. We can help you set that up. Has it been years since you updated it? It's time for a review. We can help you with that as well. Do you want to find ways to support your children and grandchildren while you're around in a way that maybe isn't as simple as just giving them money, and you want to be aware of tax issues? Talk to us. We can help with that. Are you concerned about property taxes and Prop 19, the demise of Prop 13? We can help with that. Concerned about estate taxes? We can help with that as well. Most importantly, you just want to help preserve your assets for future generations. As we talked about, there are so many ways we can help you to do that as well. So it would be our privilege to get the chance to work with you. If you're an existing client, maybe it's time for a refresher meeting. And if you haven't worked with us yet, we invite you to contact us, gilfix.com. We'll have some more information in a second. And stay tuned for more webinars. see Gilfix.com for more information, but also subscribe to our Gilfix Law YouTube channel. Just go to YouTube, search Gilfix Law. Don't miss this opportunity. Be one of the families that plans ahead. I honestly believe that in 10, 20, 30 years, we're going to see an increasing gap between the families that took these steps to protect assets and the families that didn't. So families that start out in the same place, we're going to increasingly see a gap between the families that work with a team of advisors and the families that don't. And I want you to be one of the families that works with the team of advisors to come up with the right solution for you and for your family. And hopefully that involves some charitable giving. You know, we love it when our clients are supporting community causes, whatever those may be. So please, if you want to reach us, you can of course go to Gilfix.com. We have a contact page, also Gilfix.com/my-needs. If you want to check some boxes about what you're interested in learning more about. If you're watching live, you can enter your information in the chat function or the Q&A, your phone number, your email, and we'll reach out to you proactively, but you can also call us at 650-493-8070. I think we have a different number on our website. That also works, at 650-493-8070. And we'd love to get the chance to work with you and sit down with you and come up with a plan and give you that peace of mind. We're going to get to a couple questions in just a moment, but Mike, any thoughts before we get to a couple questions and then wrap this up?
No, you know, I have the parent-grandparent perspective. Mark has that next generation's perspective. We're using Miles. He's 2 years old to give us that third perspective. We talk with him about these things all the time.
Yes.
So we're living and breathing it. And we know it pays off. It's fun.
Yeah. You know, it is. I mean, and we practice what we preach. We talk about these issues and we've set up a lot of these tools ourselves. We help many families to do it as well. So we'll get to just a couple questions.
Yeah, I see one from John. Here, should I?
Yeah.
Okay.
Go for that.
So John asks, will our Roth IRAs count in calculating the total value of the estate for estate tax purposes? Yeah, IRA, 401k, Roth, regular, it's all part of your taxable estate, as is the death benefit of life insurance policies if you own the policy. So you do have to be careful about this because a lot of folks think they're not. By the way, I'm a real fan of Roth IRAs. I mean, don't get me wrong. I think they're wonderful tools. But again, you just have to realize that they are part of the taxable estate.
Yeah, we had one question about how we meet with new clients and how that process typically works. So we don't do free initial meetings. We want to be able to serve everybody who wants to work with us. We don't have the bandwidth to do that. But we're there for you from day one. So we are billed at our hourly rates. Different attorneys have different rates. We're there from when you sit down with us to help you come up with a plan. We're not there to pitch you on our services. Hopefully you get to know us and who we are from these talks and hopefully from the community. If you do have questions and you're not quite sure and you want to make sure that we're a fit, we are happy to set up a 15-minute initial Zoom or phone call. These are questions about more details about how we do things and to make sure that you're a fit, we're a fit for you, that you're a fit for us. So we're happy to do like an initial 15-minute intro call, but we really encourage you to sit down and set the meeting. And we will always give you, from that meeting, we can kind of develop a plan. We'll give you what the specific costs would be to carry out different pieces of a plan or different options. So it's our mission to sit down with you and really get the whole story. So we don't miss any detail. The devil's in the details and the value can often be in the details. So again, we work with so many families of different backgrounds, of different types, from all over the state of California. It would be our privilege to get the chance to work with you. But if you are watching this on YouTube, please like the video, subscribe to our channel. It's a privilege to have everybody here today. We know that time is so valuable and we really appreciate you spending it here. And actually, there's one more really good question.
Great question
from Wayne. He asks, how do you integrate a special needs trust with the family protection trust? Now, we have a few webinars on the Gilfix Law channel about special needs planning. These would be separate. Special needs trust, let's say you have one child with a disability, another child who doesn't have a disability, who you just want to protect assets for. Well, you would create a special needs trust for the child with a disability to protect them. And you create a family protection trust for the other child. We very commonly will set up plans where there's a special needs trust and a family protection trust.
I think it's a different question. Okay. I think the question is, can you integrate the benefits and protections of a special needs trust and a family protection trust in one trust? So you want to include the estate tax avoidance benefit, the divorce protection benefit, the litigation protection benefit. And yes, we can. It's a more sophisticated, more detailed trust. But in some circumstances, that is exactly what we've done. I got to tell you, that took an embarrassing number of hours of research to figure out how to integrate all of these rules where we're dancing around in between tax regulations and government benefits regulations. So great question, Wayne. It can be done.
And special needs planning is a huge part of our practice. We're going to be doing actually a couple of talks with the Pacific Autism Center for Education in early November. If you have questions about special needs planning, again, check the Gilfix Law YouTube channel, subscribe. We give regular talks about that. We also co-authored a book about special needs planning. So, and that also involves multi-generational planning. So I hope you got a lot out of this. We're going to wrap things up in just a moment, but thank you so much for spending time with us. We really appreciate it. Again, subscribe to the Gilfix Law channel, set a meeting with us at gilfix.com if you want to discuss this more. There are so many things that we can achieve when we work together across generations. So I hope everybody's staying safe, sane, and healthy, as my mom likes to say. And thank you so much again. We hope to talk to you soon.